Good morning, Mr. Hewitt.
Good morning. Right, I'm going to have to get on and hopefully try and move through this relatively swiftly because there's quite a lot to cover. I want to cover the cases which you'll then see referred to in the expert report and in the judgment. So I've reached a stage in my chronology of the commencement of the Hirsch litigation in 1995, and Mr. Gammy does deal with this what happened in his report at paragraph 120. I wasn't going to take you to that, but what he says broadly is he was asked to be part of a beauty parade and gave advice to Hirsch, but they didn't get the job to actually do the litigation. But he then wrote an article about the forthcoming litigation with Mr. Brannan in 1995, and that article is in the bundle, and that's at in the additional documents bundle, the third file, and it's at tab 20, page 677 it begins on. Tab 20.
It's actually the second bundle, I think.
Oh, well. It's in my third one. I don't know. It's probably been divided in different ways. Sorry. It's tab 20, page 677 it begins. Yeah. And I want to just pick up some points from this. I'm not going to go through the whole article, but on page 678, you can see under forthcoming ECJ developments, you can see the authors say Hirsch, Pirelli and Inland Revenue must be waiting with a mixture of hope and anxiety the forthcoming decision of the European Court of Justice in the Velox case. The court is expected to hand out its decision on 11th August. In this case, the Netherlands has defended its position that its tax laws are not discriminatory on the basis of the coherence of the tax system, so-called Bachmann defence. The court is likely to explore the boundaries of the coherence defence in some detail. The judgments may have crucial implications for the Hirsch and Pirelli cases as well as the UK system of taxing corporate dividends. And I'll take you to the Wheelock's decision, which was later in 1995, where in that case the Bachmann defence failed, whereas in Bachmann it had, as you know, succeeded. Can I then turn forward to where the authors deal with discrimination, page 684. And if you just want to read under the heading discrimination on direct tax systems at the bottom of the page, if you just want to read that and the rest of the section on the next page, which discusses Schumacher, which may speed things along when we come to look at Schumacher in a moment. Actually, looking at that now, that possibly tells you everything you need to know about the Schumacher case. It sets out the facts and the basis of the decision. You can see it was a case about individuals, free movement of workers, And the point the court was making was that where you had a non-resident who worked in another state, who was resident in one state, in this case Belgium, but worked in Germany, normally it would be Belgium who would be in the best position to determine the individual's personal circumstances and give them reliefs, such as the reliefs in this case. But in the situation where most of their income, or all or nearly all of their income, is derived from the other state, Germany, then Germany was in the position to do it, and therefore Germany was obliged to grant the reliefs that it would grant to a German resident. That's essentially what the case decided. And what that case is talking about is the comparability of resident and non-resident taxpayers. So you can see the position of Mr. Schumacher. He was a taxpayer in Germany, but not resident in Germany. So the question was, should he be given the reliefs that a resident would be? And then I wanted to show you a short passage where they consider the merits of the Hearst case, which has just been, well, I think at that stage the claim had been made. It hadn't been referred yet. And that's on page 686 on to 687. It's the paragraph on 686 beginning, in the middle of the page, beginning the present cases have a number of affinities to the facts of commission in France. And if you go down to the first full paragraph on the next page.
Just while we're reading, can you just give me the signpost or the punchline? Why am I reading this?
Well, what it reflects is Mr. Gammey's view in relation to this case in 1995.
Right, but are you, I mean, on your primary submission, none of this is relevant because we can...
Yes, exactly, yeah.
But if you're wrong in that approach, are you asking us to say that the judge, shouldn't have accepted Mr. Gammey's evidence in some respect? Or why are we, I mean, other than knocking Mr. Gammey, which I understand you might do if you were cross-examining him, but you're not. Why are we reading it? Or why am I reading it?
Well, what I'm showing you is the way that Mr. Gammey, as you'd expect a lawyer to do, dealt with the analysis of the Hearst claim when he was dealing with it, contrasting to the kind of rather more unfocused approach that was taken, that you'll see from the expert report and the way that it's dealt with it. Yeah, I'm simply making the point that this is the way...
But on an appeal, if this is a factual question, I mean, we can only disturb findings of fact made by a judge if the judge has either made a finding which is unsupported by any evidence, or which is, I mean, I'll paraphrase now, but manifestly contrary to the weight of the evidence that no reasonable judge could have reached that factual conclusion. I mean, is that what you're saying, or are you just? I mean, I'm just struggling to put this into the context of the appeal.
Yes. What I'll be saying is that Mr. Gammey's evidence was, in relation to the claims that we're dealing with, was that in his view going back to 1995, his view would have been that they were going to fail for certain reasons, but it went no further than that. That's what I say about the evidence. In other words, he wasn't saying the claims are hopeless or fanciful or whatever. And so how that fits in with the judge's findings will be something we'll have to look at it when we get to the judgment to do so.
Okay, but that is why we're looking at it. Okay, right.
Yeah.
So is the Hearst case about not being able to make a group income deduction?
Yes, sorry, that's exactly, yes, sorry. It's the grouping. There were two aspects to it. There was also the tax treaties if you remember, claim, which he also goes on to deal with. But this part is just dealing with the group income election.
How far do you want us to read?
I want you to read to the paragraph which ends foreign parent companies, which is a...
Yes. So the summary is that Mr. Ganmy and Mr. Brennan thought that Hurst ought to win.
And that's what they say on page 691 in the conclusion. I'm just going to draw it. Yes, exactly. In 691, they say, based on the claims we made in these cases, we believe the action to extend the group income provisions should be successful. This would be a major victory, etc.
And what is the date of this article?
This is 1995. I'm not sure we've got the precise date.
Okay.
It followed, as I say, I think he was giving advice in 1984 to them. That was his evidence in his report. And this was a product, I think he said, of the advice that he'd been given. Obviously, he'd been thinking about it very carefully for the purpose of advising Hurst. Can I then take you on to, I was going to pass over Schumacher because you've seen what Schumacher was about and what it decided from this article, and take you to VLOX, which is in the authorities bundle, tab 46. Mr. Elox was a Belgian national who was resident in Belgium. He worked as a self-employed person in the Netherlands, and he received his entire income and was liable to tax there. He asked to deduct his contribution to a pension reserve, as it was called. In order to do this, under Dutch law, he had to be a natural person resident in Netherlands. So they said you can't do that. And the Dutch authorities were arguing that the restriction that was identified was justified on the basis of fiscal cohesion. And that was the case that Mr. Gammy was referring to, you remember, in the article. And the court deals with this at paragraphs 23 to 25 of the judgment at page 1937. Where they say, you can see in 23, the Netherlands government relies on the principle of fiscal cohesion in Bachmann, according to which there must be a correlation between the sums which are deducted from the taxable person and the sums which are subject to tax. If a non-resident can set up a pension reserve in the Netherlands and thus secure a right to a pension, that pension would not be taxed in the Netherlands, since by virtue of the double tax convention between Belgium and the Netherlands, such income is taxed in the state of residence. As the Advocate General observed, the effect of double taxation conventions, which like the one referred to above follow the OECD model, is that the state taxes all pensions received by residents of its territory, whatever the state in which the contributions were paid, but conversely waives the right to tax pensions received abroad, even if they derive from contributions paid in its territory, which is deductible. Fiscal cohesion has not therefore been established in relation to one and the same person by a strict correlation between the deductibility of contributions taxation of pensions, but is shifted to another level, that of the reciprocity of the rules applicable in the contracting states. Since fiscal cohesion is secured by bilateral convention concluded with another member state, that principle may not be invoked to justify the refusal of a deduction such as that in issue. So, put simply, if you remember in Bachmann, there was the dichotomy between whether the pension would be taxed, whether the deduction was allowed going in, whether the pension be taxed. In this case, the pension wouldn't be taxed in Holland, but that was because they had agreed with Belgium that it would be taxed in Belgium. And the European Court says fiscal cohesion wouldn't apply there. You have to give a deduction. Holland has to give a deduction, and the Netherlands have to give a deduction for the payment in, despite the fact that he's not a resident of Holland. And despite the fact that Holland is not taxing it, because under a double tax treaty they've agreed that it will be taxed by Belgium. It's also important to note.
I'm sorry, I'm being very slow. I've not understood what the difference is between that and Bachmann. In both cases, you have pension contributions payable in one state, and in Bachmann it said, well, since the pension's not going to be taxed in that state, it's permissible not to give the relief on the contributions. And in VLOX you come to a different conclusion.
But the reason that it wasn't taxed was simply because Belgium didn't, it wasn't taxable in Belgium in Bachmann. But the reason it wasn't taxed here was because of an agreement with Belgium, between the Netherlands and Belgium. If it had been another state, perhaps it would have been taxed because there wouldn't have been a double tax treaty. But there might not be one, for instance, between Holland and France, let's say, in which case it would have been taxed. So under Dutch law it was taxable, but the double tax treaty took it away. That seems to be the distinction that they're drawing. The cohesion, the point being that you don't simply look at the domestic system and see what the effect is, and does this make sense? I mean, this is what Mr. Gowing was saying. Well, does it make sense domestically? Of course, from the point of view of Holland, it made perfect sense not to allow deduction if they were not taxing the dividend. But the European Court said that's not good enough for fiscal cohesion to apply, because you've given away the right to tax to Belgium, essentially. What's also important to note is that the court says fiscal cohesion hasn't been established in paragraph 24 in relation to one and the same person by a strict correlation between deductibility. So this is making clear that fiscal cohesion to apply, it must be, the two sides must apply to one and the same person. And this is the first time that's been said, but it continues to be said thereafter in cases about.
Why is it not the same person? Why is it not Mr. V?
Well, in this case, it was the same person, but the point I'm making is that they introduced the condition that it should be the same person. So it's quite a narrow doctrine, fiscal cohesion. It only applies where the deduction and the taxation are in relation to the same person. Deduction and taxation, or deduction and non-taxation. As I say, it's the first time it's been mentioned. There's a whole series of cases after this which say the same thing. That it has to be between the same person. But this is the first one, and it is a 1995 case.
Okay. Paragraph 27 is where I assume they sum up there, because it starts with the word accordingly.
Yeah, that's the...
And then there's an extremely long sentence.
Dispositive, yes.
If at some point in the future I'd sit down with a cold towel and work my way through that sentence, is it accurate, or is there anything I need to take out of it?
This is essentially it's the dispositif, because you then...
Exactly, so I'm going to try and work my way through that, but what do you say I should be emphasising when I'm reading it? Because it's a very long sentence to get my head round sitting here at the moment.
I think it's saying exactly what I just said. Yeah, I would say it says exactly, it's a long sentence, what I just said as to what the distinction is. are not taxed in the first state but in the state of residence, but which the first state has concluded a double tax convention, even if under the tax system in force a strict correspondence between the deductibility of the amounts to the pension and the liability to tax cannot be achieved by generalising. I don't know what exactly that means, the benefit.
Well, I was.
So there isn't a correlation between deductibility and taxation in Holland, I think, what they're saying. But it has been
And what does
moved to the state of residence by a double tax convention.
Okay, and what does generalising the benefit mean?
Well, that's a good, yeah. Yes, I'm not sure I know what they mean by that phrase, but it's certainly making exactly the point that I was just making, that
Okay.
fiscal cohesion doesn't apply where it's being taxed in the state of residence rather than the state where he's working by reason of double tax convention. Because it then says, even if under this tax system in force in the first state, a strict correspondence between the deductibility of the amount added to the pension reserve and the liability to tax cannot be achieved. I mean, yes, hard to know exactly what generalising the benefit means, but it must mean that it isn't achieved in every case because of the double tax treaty. In other words, they still have to give a deduction, even though in every case Holland wouldn't be taxing the profit that comes out of it.
Okay.
It's that particular point. It's not strictly relevant to our case because it obviously that doesn't apply. Although not the same person does apply in our case because. But the point I'm really making is that VLOX shows the narrowness of the fiscal cohesion doctrine, and that's why, if you remember, Professor Tiley, in the 1995 article that I showed you, said it looks like after the cases in 1995, which include VLOX, that this is the tax authorities will not be able to rely on Bachmann very, very often. And in fact, that transpired to be correct. I don't think anyone won a case on the Bachmann ground until well into the 2000s, from my recollection. So the next event is Mr. Verkuen's case is going through the Dutch courts, and he was successful, you may recall, before the Dutch Court of Appeal on the 10th of April 1996, a judgment was given. And that's tab 25 in the additional documents bundle. If I can just take you to the reasoning of the court. It's on page 817.
I'm sorry, where are we?
It's in the additional documents bundle, tab 25, page 817. And it's paragraph 6.5 on to 6.8 in relation to freedom of establishment. So 6.5 is making the point derived from a number of cases, including Schumacher, but also, remember, Commerzbank, that the distinction on residency is an indirect discrimination on nationality. And then they examined whether there's unequal treatment, that was between dividends received from non-resident companies and dividends received from resident companies, and they said that was the case. There's indiscrimination, and finally the court examined whether there was a justification for the difference in treatment. Sovereignty of the member state to give form and subsidy to the tax system. However, discriminatory regulations contained therein are assessed against the treaty. The Court of Justice applied a strict standard in this regard by determining that discrimination is only permitted in order to maintain the coherence of a tax system. It's Commerzbank and Bachmann. The Act aims, as appears from legal history, to make investing in Dutch shares attractive to private individuals residing in the Netherlands. This cannot be regarded as a measure in which the coherence of the tax system is at stake. There's no justification. And then they go on to some other points, and whether it could be in conflict with free movement of capital, which is an alternative ground. So that, what then happened was that decision was appealed to the, I think the equivalent of the Supreme Court in Holland, and they referred the question to the European Court, which resulted in the decision which we'll come on to.
Was there any evidence as to whether anybody in the UK would have actually had access to this document or have...
No, and the point the judge makes about it is there was no evidence that anyone would have, a UK advisor, so the UK industry would have known about this.
So how does this fit within the Supreme Court's vision of what would have to happen after they gave their judgment in number 2?
Yes, and it wasn't our case was not, everyone would have known about this at the time. Our case was, what this reveals is that whatever is decided in Verkuyen, if it is relevant, was perfectly discoverable many years before.
Well, if somebody had
if it's
thought
so
about it and gone to the archives of the Dutch...
No, if someone had thought
well,
about
not
it...
archives, to the Dutch Court of Appeal...
No, that's not the point, my lord. The point is that if someone had thought about it, they could have come to the same conclusion as the Dutch Court of Appeal, or indeed Mr. Verkuyen, that this was a claim that...
If a Dutch lawyer could have thought about this point, an English lawyer could have thought about this point. That's what you're saying.
That's the point. And the answer to that seems to be, fog in the channel, essentially, that English lawyers were well behind continental lawyers as regards European law. I mean, Mr. Gami says that, and the judge says that, I think, as well. There's no evidence for that, obviously. Whether that is the case, but that's an assertion that's made. Somehow, although continental lawyers could see these things, English lawyers couldn't for some reason. I don't really understand it, and all the evidence suggests the opposite. If you look at the cases that were being brought, many of them are from the UK. I've shown you some already. Daily Mail, Commerzbank. We know that Factortain, one of the biggest European cases, came from the UK. There have been Professor Barnard goes through this in her report on various cases we brought. So it doesn't seem to be a proposition that has any support. But anyway, that's what the judge said about it. And the judge didn't seem to take this point. The judge thought we were saying, well, they ought to have seen this decision at the time. But that wasn't the point we were making. Yeah, as I said, there isn't any evidence one way or another as that anyone was aware of it.
Do you accept that the question the Supreme Court requires to be answered is what you would have been told if you'd asked an English lawyer, rather than? Is there any suggestion you should have asked a German lawyer? Or
no, But equally, I don't think there's any suggestion that the answer would be any different. It's the same law. The German lawyer and the English lawyer have both all the same case law available to them, the same treaty. They're not in any different position. So it's hard to see in principle why there should be any difference between the notional advice you would get from a German lawyer and the notional advice you would get from an English lawyer at the same time. The next event is in the Hirsch litigation. Mr. Justice Neuberger was sending off a reference in 1998 in Hirsch.
Sorry, you don't want us actually to go to the judgments of the European Court of Justice?
Well, I was going to come to them when I got to 2000. Sorry, and I'm trying to deal with this
okay.
chronologically.
Yeah, no,
so I'm going to come back to that.
Sorry.
So a reference was sent off by the Hograd, I think it's called.
Yeah.
But in the chronology, at this point, Mr. Justice Neuberger sent off a reference. But in doing that, he had to make a few decisions about what was going to be in the reference. And one of the questions he had to deal with was whether he should say that ACT was an advance payment of corporation tax, or was corporation tax paid in advance, essentially. And there was some argument about that, and he concluded that he would say that as a matter of domestic law. And there's a judgment which is in, I don't think I need to actually take you to it because it's not, in the joint supplementary bundle of tab 11, you can see the judgment that Mr. Justice Neuberger gave, where he said that's what he would say, and that's what we find in the order for reference.
What else could it be suggested it was?
Sorry?
What else could it be suggested it was?
Well, good question. I wasn't involved at that time, so I don't know what.
It's called advance corporation tax.
And it's set against corporation tax. That was the point that was being made. In principle, it's set against corporation tax. Obviously, it might not be if there is no corporation tax to set it against. But
it's also set against the individual shareholder's income tax.
Yes, it is.
So
it's also set against the individual
that's right,
taxpayer's
that's the
income tax.
The slight complication that it operates as part of the imputation system as
So
well.
it does two
in a sense, although
it's not just early payment of corporation tax, it's early payment of corporation tax which also franks the income tax obligation of the shareholder.
Well, strictly speaking, it's a tax credit that does that. And then there was a case called Pirelli where there was an argument about whether the tax credits, because the UK legislation didn't explicitly say that you had to pay ACT to get a tax credit. And we had this debate in Pirelli, and the House of Lords eventually decided that it was implicit in the legislation. But strictly speaking, you don't get the ACT as a tax credit, you get a tax credit, which was of the same amount generally at that time as the ACT. But it did operate in a sense as part of that. But it also was paid. It was a form of corporation tax paid in advance, and the reasoning from the 1972 when it was introduced was, well, we're going to have to give tax credits to people when we pay dividends to them, and in fact, pension funds or whatever could make claims for tax credits immediately. They got the dividend. I mean, they were able to claim it then. The problem was the corporation tax was only going to be paid 9 months after the end of the accounting period. And might not be paid at all. And so it was thought, you pay the corporation tax in advance to make sure it's being paid to notionally fund the tax credit that's being given. So that's basically maybe later. I don't really have that. So Mr. Justice Neuberger decided that, and it went in the order for reference. And if I could just then take you to the written observations in Hirsch, just to show you that these arguments that the claimants say could only be discovered when the Hirsch judgment was came out were actually being made in the written observations in that case. So this is in the additional documents bundle, tab 31 first. These are the observations of Metal Gazelle shaft. And if we look at paragraph 4, if you look at page 921, paragraph 3D, you will see a reference to this point exactly being made. And then if you turn on to paragraph 32, which is on page 928, and you have to look at paragraph 31 to see that this is the argument that the defendants, the revenue or the UK government were putting forward. And this is an argument that is also put forward in the European Court and dealt with there.
Sorry, which paragraph?
Paragraph 31.
Thank you.
On page 928. And you can see the answer to that in paragraph 32, 1 and 2. And then on page 934, you can see the argument at C in bold, which is an argument put forward by the defendants that the ACT system is designed to avoid double taxation by matching payment of ACT with a tax credit. If the plaintiffs are right, the ACT doesn't lead to no charge at all, as no ACT will be payable on a dividend paid to the non-resident parent by the resident subsidiary. And they say it's already been referred to. The answer is very short. It's misconceived. ACT is an advance payment of corporation tax. A subsidiary which pays a dividend to its parent is not required to pay ACT on such occasion because there is a group income election force will account for corporation tax as profits. The only advantage of being able to make a group income election is that the corporation tax does not have to be paid early in the form of ACT. A non-discriminatory ACT system would still lead to a charge to corporation tax on the profits of the subsidiary. And that, as I'll show you, is exactly the answer which the European Court gave to that point, which was ACT is an advance payment of corporation tax, and in both cases, where you've got a foreign parent and where you've got a UK parent, the subsidiary will pay corporation tax. It's simply in the case of the foreign parent, you have to pay it earlier, and that's the discriminatory treatment. And then you'll see on page 935, in paragraphs little 1, 2 and 3, how they deal with, how they deal with the Bachmann argument. There has to be a direct link between the deductibility of contributions and the taxation of sums payable.
This document was registered at the court in March 1999. How does it inform what the position was in '96?
Well, what it does is show that the decision of the court and the reasoning of the court was not anything new at the time it came out, because the basis of the case that Hurst made some difference must be this couldn't have been anticipated. This was new reasoning that came out. Something entirely new that we couldn't have anticipated and changed everything. And we'd suggest that wasn't the case. It was entirely in line with what was being argued. But it also, the fact that they were arguing it in '98 in the written observations was rather suggestive that would be an argument that they would have put if you had been asking it in '95, and there's no reason it's any different. Nobody's suggesting anything changed between '95 and '98 in relation to this point. So it's a point that's perfectly obvious from the beginning. It happened. I think there was some procedural reason why there was a delay between the issuing of proceedings and the reference taking place. It was about 3 years. I don't know what it was, but there was obviously some problem. We also have the Hurst observations at tab 33. We make the same point. At page 980, paragraph 5. And then at page 983, in the middle, if you look in the middle of the page, paragraph 13, the defendant's contention in relation to this question is summarised at paragraphs 45 and 46. These paragraphs suggest that the rules are designed to ensure that ACT is collected at some level in the group, and that if payments can be made free of ACT to non-resident parents, that could lead to no ACT being collected by the UK. And then they say these contentions ignore the nature of advanced corporation tax. See paragraph 9. To suggest that no ACT, going down to the middle of the paragraph, no ACT would be collected is literally correct, but obscures the fact that the relevant amount of tax would be collected from the resident subsidiary as corporation tax in the ordinary course. It's a fallacy to assert these provisions are necessary to ensure that advanced corporation tax is paid at some level in the group. As already been pointed out, the resident subsidiary would pay the relevant amount as corporation tax in the ordinary course. It is true that if the non-resident parent then made a distribution, no payment of advanced corporation tax would be due from that company. But that simply reflects the fact that the non-resident parent is not chargeable to corporation tax in any event. By that it means in the UK. And that's exactly the point which the European Court made in response to the same argument by the UK. So there was nothing new in Hurst, and indeed that was Mr. Gammey's view. Not surprisingly, since he had predicted in 1995 that Hurst would be successful. His view was nothing surprising about the result in Hurst. Can I then take you to, just hopefully briefly, to an article, because it is referred to a number of times, both in Mr. Gammey's report and in the judgment. It's by Mr. Loden, Professor Loden, The Imputation Systems and Cross-Border Dividends. and it's in the joint supplementary bundle at page 296. And it's about imputation systems and cross-border dividends. And if you look on page 297, in the first column, just above where it says 1.1 neutrality problem, there's a paragraph. For a long time there's been discussion whether the existing imputation systems are in accord with the demands of non-discrimination of the Treaty of Rome, and whether they could be said to form an obstacle to the free flow of capital in violation of the Maastricht Treaty. The question has now become crucial as the imputation systems for shareholder taxation in both Germany and the UK recently have been challenged for violating the principles of the EC and EU treaties. It's expected to be brought before the European Court of Justice. I think the UK one that he's referring to is the Hurst litigation. But he then goes on to talk about the interpretation of the treaty rules. On page 299, 2.2 in the second column, it's difficult to predict what the outcome will be in the ECJ. The treaty rules are not clear enough to make the outcome obvious, and there is very little guidance to be found in earlier decisions of the ECJ. The Bachmann case offered the opportunity to the ECJ to take a position concerning the question whether different treatment of foreign investments in relation to domestic investments constitutes discrimination in contradiction to the EC rules, but it did not address the question. In VLOX, the ECJ considered the argument of fiscal cohesion invalid when a state had abstained from applying that principle in a double taxation treaty. In the Svensson case, which did not concern taxes but subventions of interest payments on housing loans, the ECJ found that it was against the community rules and the free movement of capital to grant the subvention only under the condition that the loan had to be taken in a domestic financial institution. Thus, more favourable rules for domestic loans than for loans taken in other member states were not allowed. Another factor in favour of an ECJ decision denouncing the German imputation system as discriminatory and in violation of the free movement of capital, and thus contradictory to the treaties, is ECJ policy. So he's referring there to a potential challenge, which I don't think in the end actually happened, to the German imputation system, which didn't give, I think in the relevant part, didn't give tax credits on dividends, foreign dividends. The ECJ is very faithful to the basic principles of the treaties, such as the three basic freedoms of mobility of capital, goods and persons, as important fundamentals for the creation of the internal market. It has demonstrated great independence and has not hesitated to take decisions for far-reaching policy implications in order to fulfil the basic aims of the treaties, especially in situations where the member states have been slow in agreeing upon the practical implementation of those principles. And then he goes on. I don't know if I've got time to read the rest of that, but it's worth reading. He's talking about the actions by against the German government and the UK government. The UK, I think, being, as I say, the Hurst case, and the German being on the imputation systems. If you drop down a few paragraphs to just below the middle, it begins whether or not the German imputation system's treatment of dividends on shares of companies or other member states will be brought before the ECJ, and whether or not the court will find the German rules contradictory to treaties. The discriminatory treatment of dividends on shares of companies from other EU states will affect investments in a way that is not compatible with the economic integration of Europe.
Just out of interest, on the preceding paragraph, it says a joint action undertaken by the German government together with the British government, and then the UK being another country in which the imputation system has been challenged as discriminatory. And the footnote is see more below page 10. Do you know what that is?
I mean, I'm pretty sure he's referring to the Hurst case, but I don't think we have page 10.
Well, it doesn't seem to be the right. I mean, I'm just not sure what.
It may be a different article in the same journal on page 10. We've got this one only goes to page.
Well, this article is at page 233, so I'm just struggling to understand what that is a reference to.
Yeah. I think it must be some other part of the review. We might be able to find out.
Somebody behind you, I'm sure somebody behind you will be able to tell us what that is a misprint for.
Yeah. Yeah.
I remember this.
But in any event, his conclusions are on page 303. Well, a conclusion on page 303 in the second column, the first paragraph, main paragraph, first full paragraph. Whether or not the problems caused by the imputation systems will be brought before the ECJ, or whether or not the imputation systems will be found to obstruct the goals of the EU, the practical effects are reason enough for demanding reforms. And then he refers to the Rudin Committee criticising the existing imputation systems. Now, what the judge said about this this is what Mr. Gami said in his report and in his cross-examination, that this was the only article that he was aware of that touched on the question of imputation systems and the challenges. What the judge said about it was, well, it doesn't show that the consensus has been dismantled by this date. But in my submission, what it shows clearly is that Mr. Loden, Professor Loden, as I say, sorry, yes, Professor Loden, was clearly not part of this consensus, because his view is that the position is unclear as regards what will happen in relation to imputation systems. It might go either way, in other words, what the result will be. He's not saying, as I think Mr. Gami was suggesting, the general view would be they'll be fine, these imputation systems, because for the various reasons Mr. Gami gives, that there is a consensus that they're all fine. So, whatever the scope of this consensus, it certainly didn't involve Professor Loden. And this is the only evidence we have of someone considering the point in any of this period at all. So, what I say about this is that it demonstrates that the true position was that the position was unclear, which is what I'm going to submit Mr. Gami was actually saying was the position. The position was unclear in this period. It could have gone either way. There was no authority. There was no direct case about cross-border dividends and Article 50 and the non-discrimination question or fiscal cohesion. I think that's common ground. There was no authority.
Again, can I just be clear what your... Is this something along the lines of the last one, that if you'd have asked an English lawyer, there's no reason to think that they wouldn't have given you the same sort of view that this Swedish academic is giving? Or what?
That the position was unclear, yes. But it's also going to be answering when the judge does make a point about this article in his judgment, so I thought I ought to show you that.
Oh, okay, well, we'll wait. I'll wait until we...
Wait to see what he says about it, yeah.
Yeah, I noticed Mr. Gami was at least checked out the description of British tax law in this article.
Yes, that's another point, sorry, to make. Mr. Gami makes that in his report, that he was involved in this article. Yeah. He doesn't. He couldn't find any evidence in his papers as to what he'd actually done, I think he said. Okay. Can I just give you the references of where he deals with that? It's in his report, paragraphs 134 to 135, and paragraphs 204 to 206. And he talks about it in the transcript of cross-examination, internal page 48, line 9, where I was asking him, was there any written evidence of any of this, and he said the nearest thing is this article by Professor Lawton. I've now reached, I think I better press on, I've now reached Verkooyen. Can I look very briefly at Verkooyen? It's at tab 49. You'll have seen that Verkooyen is a case about an individual taxpayer who wasn't able to claim particular relief, a sort of personal allowance in relation to dividend income of 1,000 euros, I think, in relation to his dividends from shares outside the Netherlands. And he was claiming that that was a breach of freedom of establishment, free movement of capital, etc. Now the court dealt with it on the basis of free movement of capital. And where they deal with the question of restriction is at paragraph 34, which is on page 2034. Paragraphs 34 to 36, which are if you could just look at those. And then there is a lot of discussion about particular provisions in relation to free movement of capital. You can see Article 73D(1). And what the effect of that is. And that's discussed between paragraphs 37 46. And what they're essentially saying is that the difference in you can't tax residents and non-residents differently if that amounts to discrimination, covert discrimination, I think we call it. So it's simply an application of the normal principles of EU law. And then at paragraphs 46 onwards, they consider various justifications. Promoting the economy, mention 47, which is not rejected as justification. And then they deal with them preserving the cohesion of the Netherlands tax system at paragraphs 56 to 58. where they say in 58 no direct link exists between the grant to shareholders residing in the Netherlands of income tax exemption in respect of dividends received and taxation of the profits of companies with their seat in another member state. Two separate taxes levied on different taxpayers. So they're straightforwardly applying the principles that we've seen set out in Bachmann and in VLOGs in relation to fiscal cohesion. And then they talk about loss of revenue, which is not a justification. I mean, I think that goes back to Commission in France. And then the idea that other advantages might be set off against it. Again, that's rejected, and that goes back to the Commission in France, as you can see from the citations. So in my submission, there's nothing earth-breaking in Verkuyen, and as Mr. Gami points out, it was a case about individual taxpayers, not companies, not subsidiaries. Didn't concern double taxation treaties, and for good measure, the Dutch operated a classical system rather than an imputation system. And Mr. Gami deals with that, just for your note, at paragraph 179 of his report. And then we have Hurst, which is at tab 50. And the court turns to the arguments put by the various governments at paragraph 52 on page 2087. The arguments being, among others, that the argument that we've looked at, that the purpose of the group income election system was to ensure that ACT was paid once, but the effect of this would be it wouldn't be paid at all because the non-resident parent would not be liable to ACT and the subsidiary would escape ACT by the group income election. And you say these arguments cannot be upheld. First, insofar as advanced corporation...
So where are you?
I'm sorry, I'm on page 2087, paragraph 52.
No, para 52 is not on page 2087.
Oh, sorry. I'm dyslexically reading it. It's 2078. Sorry, that's my fault. 2078, yes, sorry. Para 52. Insofar as advanced corporation tax in no sense of tax on dividends or rather than advanced payment of corporation tax, it's incorrect to suppose that affording resident subsidiaries non-resident parent companies the possibility of making group income election would allow the subsidiary to avoid paying any tax in the UK on profits distributed by way of dividends. The proportion of corporation tax will be paid when the mainstream corporation tax liability falls due. It should be remembered that a resident subsidiary of a company resident in another member state is liable to mainstream corporation tax in respect of its profits in the same way as a resident subsidiary of a resident parent company. Consequently, to afford subsidiaries of non-resident companies the possibility of group income election would do no more than allow them to retain the sums which would otherwise be payable by way of advanced corporation tax until such time as mainstream corporation tax falls due. They would thus enjoy the same cash advantage as resident subsidiaries of resident parent companies, there being no other difference. And then secondly, the fact that a non-resident parent company will, unlike a resident parent company, not be subject to advanced corporation tax when it in turn pays out dividends cannot justify denying the resident subsidiary the possibility of exemption from payment of advanced corporation tax. The fact that a non-resident parent company is not liable to advanced corporation tax is attributable to its not being liable to corporation tax in the United Kingdom, since it is subject to that tax in the state of establishment. Logic therefore requires that a company should not have to make advance payment of a tax which it will never be liable for. That's the same point. They can't be liable to advance corporation tax, they're not liable to corporation tax. Sorry.
Picking up the point that Mr. Barnes made, his written observation.
Exactly, yes. Precisely. So, and they also reject the Bachmann argument, paragraphs, this is on 2080, paragraphs 69 to 70. In fact, it goes on to 73.
And you're saying that this reasoning was all entirely predictable?
Yes, exactly.
So
and it was the reasoning that was argued in the written observations and to some extent was anticipated by Mr. Gammy in 1995. So there's nothing new in any of this, is what I'm saying. There's nothing earth-shattering. When you read this judgment, you wouldn't think, oh, the court has made a great advance and done something that means I'm changing my view of things. And that's what the judge thought as well, as regards. And indeed what Mr. Gammy thought. Yes. I mean, this is all in really, obviously particularly focused on FCE, who say this this made all the difference. That the yes, nothing particular in Mr. Gammy's report on this, but he does deal with it in cross-examination. Internal pages 73.4 to 74.12 and 104.15 to 105.7, just for the note. So now we've reached the stage where claims have been brought. So we're reaching 2002 by Avonic, 2003 claims are brought by BAT, and a number of other groups made claims in 2003, and I think in 2004 as well. And then we have the final three cases that Mr. Gammy refers to in his report as being the stepping stones necessary for the decision in FII. It's Lentz, Mannanen, and Marks and Spencer. Just in the interest of time, because we are moving on, I'll deal with Mannanen, which is in tab 52. This was the judgment was delivered on the 7th of September 2004. And broadly speaking, this is the Finnish legislation that was under review. The domestic system in Finland provided for essentially an imputation credit, which had the effect of giving credit over in the end for the amount of tax paid by the Finnish subsidiary. So domestically, the overall effect of the system, there's a number of stages to it. The overall effect of the system was to give credit for tax paid by the subsidiary in Finland on a dividend to its parent. Whereas a Finnish parent with a foreign subsidiary didn't get any tax credit at all under the Finnish system. So that was the distinction. So this was a case clearly about cross-border dividends. And the question was whether that reached was it free movement of capital? And if you just look at what the court decided in the holding in page 2114. It says legislation such as that issue had a deterrent effect both on national taxpayers seeking to invest their capital in companies established in other member states and on such companies seeking to raise capital in a member state. It constituted a restriction of free movement of capital, prima facie prohibited. It derogated from a fundamental freedom, was limited to the requirement in Article 58(3). The national law were not to constitute arbitrary discrimination or disguised restriction on the free movement of capital, to be interpreted strictly so that it was not the case that any tax legislation making a distinction between taxpayers by reference to the place where they invested their capital was automatically compatible with EC treaty. And that for unequal treatment such as that issue to be permissible, it had to either concern situations that were not objectively comparable or be justified by overriding reasons in the general interest. And then they conclude the situation of Finnish taxpayers who receive dividends from Finnish companies on the one hand and non-Finnish ones on the other were in relevant respects comparable, that even if a direct link between the tax advantage concerned and the countervailing tax charge was shown to exist, the measures in issue did not appear to be necessary in order to preserve the cohesion of the Finnish tax system, and the undesirability of a reduction in tax receipts and practical difficulties in determining the amount of tax paid, which had also been pleaded in support of the measures, could not be regarded as overriding reasons capable of justifying an obstacle to the free movement of capital. And the answer to the questions referred was Article 56 and 58 precluded legislation whereby the entitlement of a person fully taxable in one member state to a tax credit in relation to dividends paid to him by limited companies was excluded where those companies were not established in that state. So I think Mr. Gammy's point is that it wasn't until that decision that you could see, if you like, almost for sure, that the position of foreign subsidiaries and domestic subsidiaries were not necessarily comparable. Sorry, were comparable, not necessarily non-comparable. They were comparable in certain circumstances. However, we then very interestingly have a record of Mr. Gammy's views in relation to dividend taxation in his decision, Special Commissioner decision, in Marks and Spencer. And he refers to that in his report, and he says, in fact, in his report, if you want to see what my opinion was at that time, look in Marks and Spencer's, you'll find it there. And we have, I hope that's been added. I think we had the Special Commissioner decision, but it's been added to your...
Just before you go there, so there were three cases. There was Lentz, Maninen, and what was the other one?
Marks and Spencer.
Oh, it is Marks and Spencer.
It is Marks and Spencer.
Sorry.
And the reason that Mr. Gammy thought it was so important was you can see he decided that there was no comparability in Marks and Spencer, and that was overruled, if you like, by the European Court. So I think at that stage he finally gave up and accepted the position. But even after Lentz and Maninen, he was still, well, sorry, before, to be fair, this is before Lentz and Maninen, but in 2002, in his decision in the Special Commissioners, he was still putting forward the view, and you can see that if you've got the, I don't know if you've got the Special Commissioner decision, hopefully it should be part of the additional documents and the application bundle, the extra bundle that we added some things to. I hope it's either been passed up or has been put in the bundle, I don't know. Do you have that? It's the 2000 Marks and Spencers and Halsey Special Commissioner's decision. You have it.
I have it.
Yes.
Now, this was a case about loss relief, if you remember, cross-border loss relief. But in the course of it, of the decision, Mr. Gammy and Mr. Avery Jones talk about dividend taxation. And you'll find that on page 232, I hope, into paragraphs 104 to 105. If you just want to quickly skim through that, you'll see that he's making very many of the points that he makes in his report.
Of course, this passage isn't about discrimination at all, is it? When you get to paragraph 106, with reference to consistency with the approach adopted by the Court of Justice in similar contexts of deciding whether there's discrimination. I don't see actually why paragraphs 104 and 105 are of particular relevance or help us.
Well, they do. If you're looking at Mr. Gammy's report, he does tell us in his report that you should look here to see what his view was. And I agree, it's not strictly... What he's saying is there are all these different factors that you might take into account, parent subsidiary directive and whatever, which all indicate the position as regards dividends. And he then goes on to say that these points confirm our view the comparison we have to make is by reference to treatment according to the losses, whether they arise in the UK or foreign subsidiaries. In deciding whether we're comparing like with like, therefore, we need to consider how the activities are dealt with. So he goes on to consider a question of comparability, otherwise like with like. And his conclusion, or the Special Commissioner's conclusion, was that the foreign subsidiary was not comparable to the UK subsidiary in this case, and for that reason, there wasn't any breach of the treaty. And you can see that on page 235 in the conclusion. Just at letter J, number 2. The United Kingdom is not required to accord the same group for losses incurred by the appellant foreign subsidiaries as it does for losses incurred by United Kingdom subsidiary of the appellant. The foreign subsidiaries, being outside the scope of the United Kingdom tax, with respect to the activities concerned, are not in an objectively comparable situation to a United Kingdom subsidiary, which is within the United Kingdom and taxable in respect to its worldwide activities. application of a different rule to situations are not objectively comparable, not amount to discriminatory restriction in the field of establishment. So that was the reasoning. That what the court actually decided in Marks and Spencer's in the end, in 2005, was that there was a discriminatory restriction, but it could be justified by a number of justifications which were put forward, which the court put forward. And I think Mr. Gammie's point in his report is, at that stage, he realised that he was wrong about this, and that it was then possible to say that the claimants were going to succeed in the FII case. But it wasn't until these cases, Mannanen, Lentz and Marks and Spencer's had been decided that you could say that, in Mr. Gammie's view. I wonder if I should now take you to Mr. Gammie's report.
Before you do, just to make sure I understand the point you're making, you say that Mr. Gammie's evidence is that until this trio of cases, it couldn't be said that a challenge of this nature would succeed, and you say that's the wrong question anyway, because you don't have to show that the challenge would succeed, you only have to show that it was arguable. Is that the point?
That's right, and what Mr. Gammie was addressing in his report was not the question for the court as to whether there was a worthwhile claim, whatever that meant, because he says, I'm just going to take you to that, he says quite clearly he's not expressing any view as to what that meant, what the standard was. It's for the court to decide. He's simply telling you what his view was, or his view, and in some cases his view, but the view that he also thought was held by others at the time. So that's the position he was taking. But what he wasn't saying, my submission was, the view taken at the time was that the case was hopeless on discrimination. The view taken at the time was that the arguments on incompatibility of the provisions to EU law were hopeless.
Because nobody thought there was an argument on incompatibility.
No, but what he was saying was if, well,
that's the point, isn't it?
Yes, nobody was thinking about it.
As I thought your submission to us yesterday was, Mr. Gammie's position was that nobody thought that anybody would actually raise an argument about incompatibility. And so I never got to deciding whether if they did raise such an argument, it was a good one or a bad one.
Yes, but what he was also saying is, what he also says is, because he does address this at some points, that his view was that, his view would have been at the time that the argument would have failed. Yeah. That's what he's essentially saying, and that's the view he's attributing to others, if you like, the tax community, that their view would have been that the argument would have failed. That's what he's saying, and he expressly says, I don't know what effect that will have on the litigation. I'm just telling you what the view would have been. It's for the court to decide. Essentially, what he's saying is that there was uncertainty at the time, which is obviously correct, because there weren't any cases on cross-border dividends until we got to Lentz and Mannanen, effectively. And so his view was, if there were no cases on it, then you couldn't say, first of all, you couldn't say the position was clear, but secondly, he was just expressing the view as to what he thought would happen if the court did decide it, essentially, and he thought that it would fail. Now, that's a perfectly respectable view to take, but it doesn't answer the question in my submission that the court has to ask in this case, because it is absolutely clear, and we'll show you, hopefully, when we look at the judge's judgment as well, that the Court of Appeal has sort of addressed this point, that it's not a question of weighing up the probabilities as to whether something will succeed or not. in my submission, it's simply a question, can it be shown that this argument was hopeless and therefore you couldn't discover the mistake? Because even if you ask someone, they would say, no, it's hopeless, forget it. And that is where that's the standard that you have to reach. So can I just take you to the report and see what it said? It's behind tab 7.
In which bundle?
I'm sorry, it's the additional documents bundle, file 1. On page, again, it's on page 89. And if you look at page 96, in paragraph 15 on page 96, he states something about his understanding of the Supreme Court decision. Not as regards the standard, but just it really falls to be resolved by an objective assessment of legal thinking at the time, rather than by reference to specific considerations as to whether to commence litigation, which is obviously correct. And then he says in 16, in this respect, as appears from our decision in Marks and Spencer, Dr. Avery Jones and I considered that community law at that time did not support the claim in that case. He's talking about Marks and Spencer, I think. In my view, our decision in Marks and Spencer correctly reflected the state of relevant legal thinking in community law as it affected the member states' direct tax systems as it had developed to that point in time. We were not alone in so concluding. Even if others had hoped otherwise, the claim in that case might perhaps be best characterised as pushing the boundaries and seeking to break new ground. Prior to Marks and Spencer's claim, relief for cross-border losses had been seen as something requiring community legislative action. In my view, the ECJ's decision and its invention of new grounds of justification, by reference which a member state's direct tax rules could be assessed, reflected the groundbreaking nature of his decision. Accordingly, to my mind at least, there is a difference in a situation in which legal thinking has progressed to a point at which it is recognised the conditions exist which would enable a person, if so minded, to issue a claim, if you like, that thinking has progressed beyond the seed of the idea to the point at which the potential to issue a claim is recognised. And the point at which legal thinking is sufficiently crystallised to characterise the claim as having sufficient prospect of success to be characterised objectively as worthwhile or valid. There have been good grounds for supposing that, rather than, for example, groundbreaking or speculative, as I described the tax credit claims in House.
He shouldn't have been giving that view, should he? That's not for him to say. I mean, that's the question for the court.
It is, but it in a sense indicates what his thinking is, because if the first of these, thinking has progressed beyond the seed of to an idea to the point where the potential to issue a claim is recognised, well, that is sufficient if you get to that stage. But what he's then going on to talk about in this report is when legal thinking is sufficiently crystallised. So he goes on to say in paragraph 18, beyond that observation, however, I have not sought to express a view in my report, whatever standard or percentage the Supreme Court may have had in mind, in concluding as it did in paragraphs 251 255. Ultimately, that's a matter for the court's decision with the assistance of my report and any other evidence it receives. What I have sought to do in my report is that my understanding of the relevant EU law as it developed, and as it was generally understood in terms of received legal thinking over the period in question, based on my interaction with other actors in the field as described in my report. And then he goes on to explain in paragraph 19 why he went beyond 18th December 2003 where he says, "It seems to me, however, that developments after that date may nevertheless offer an insight into the legal thinking as it existed at that date." That is 2003. Thus, as I described, accepted legal thinking on the ECJ's direct tax case law as it developed to 18th December, as reflected in my decision of Marks and Spencer, would not have supported the idea the United Kingdom, contrary to its domestic law, was bound as a matter of community law to give effect to a claim by a UK resident parent company for release of losses incurred in another member state. At most, it would be known that Marks and Spencer was seeking to break new ground in this issue, and that a reference had been lodged. One has to look beyond 18th December to appreciate the novel approach adopted by the ECJ in that case. Accordingly, in approaching my task, I have not drawn a firm line, but looked beyond it to identify developments in the case law post-date 18th December 2003. And then at paragraph 51, he sets out a summary of the situation at the start of 1996. And this is the point that was examined. As to whether this was his view of the position or whether he was saying that any country position was unarguable. And what he says, because he states, the difficulty is that he states these as just absolute propositions, you can see in this report. He doesn't say.
Where are we?
51, sorry, paragraph 51, page 105. Paragraph 51, where he's summarising the situation at the start of 1996. He talks about the long-standing accepted understanding of the position. Then he says, furthermore, the situation of a subsidiary established in another member state is not comparable to the situation of a subsidiary established in the parent's member state. My point being, this is a very absolute statement. He doesn't make clear there whether he means that was his view, that was the best view, or that was absolute, because there's no case law which says this. This is simply, at 1996, there's no case law, there never was any case law that said this, in fact. And then he talks about the parent subsidiary directive. And then he just deals with Bachmann, the cohesion basis, in paragraph E. Even if there had been a basis for suggesting that the UK treatment of foreign dividends gave rise to an issue in respect of which ECJ was competent to deal, the UK system was entirely rational and corresponded to the systems of several member states and could therefore be justified on the cohesion basis. And then he deals with Verkuyen, paragraph 53, and this is a summary which he deals with slightly more detail later on, where he makes the point that it didn't involve intercompany dividends, in respect of which foreign tax credit was accorded as required under the parent subsidiary directive, concerned a member state that operated a classical system and did not seek to integrate the corporate and personal income tax systems. So what he's saying is that this Verkuyen didn't have any of the elements that I have referred to above, which are relevant to this issue. But then he talks about Mannanen, and says in paragraph 55, the particular relevance of the Mannanen decision and development of the ECJ's case law was reflected in the Belgian finance minister's remarks, Brussels conference. Lentz and Mannanen have confirmed a new evolution in the court's case law. Whereas previous decisions only concerned the tax of a single member state, those judgments the court have decided that applying their own tax rules, the member states must take into account the consequences of the tax systems of other member states, etc. And then in 56, by the time the AG issued his opinion in FIGLO, the ECJ had also decided in Marks and Spencer, establishing that there were circumstances in which a member state might have to give relief for losses incurred by a foreign subsidiary of another member state. This was a surprising development, given that the losses would initially have arisen and be computed under the rules of the subsidiary state of establishment, rather than under the rules of the parent company's state of establishment. He finally says, the ECJ's decision in Marks and Spencer was delivered on 13 December 2005, From there, it was a relatively small step for the AG to conclude as he did in FIG law. However, the proposition that member states are not required to take account of taxpayer in another member state remains true to this day in the case of juridical double taxation. The analysis or an approach...
I'm sorry, Mr. Yu, what is the significance of juridical double taxation as opposed to any other form of double taxation?
Juridical double taxation is double taxation of the same taxpayer.
Right. As opposed to economic double taxation.
Which is the double taxation of the same income in the hands of two taxpayers. So juridical double taxation would arise where there is a withholding tax or something on a dividend. So if the state of where the company is resident, who pays the dividend, imposes a withholding tax on the dividend, taxing the shareholder, and the state of residence of the shareholder also taxes the shareholder, that's juridical double taxation. And you do get relief for that, or in the UK, for the withholding tax against your tax liability. But what the European Court has said, that's what your reference is, the European Court has subsequently said in, I think about 2009, that there's no requirement to provide relief for juridical double taxation under European law. So there's a distinction between economic and juridical double taxation.
Thank you.
I think that's the reference he's making. Yes, so can I then take you to 205, page 151. In 204 he says, how then might the principles being developed by the ECJ apply to a case in which the origin state, the United Kingdom, did exactly what Peter Wattell has identified, and which the parent subsidiary directive required, and relieved the double taxation that was implicit in a decision to invest abroad, so that the taxing jurisdiction of two member states was engaged rather than that of a single member state. The only material I have identified that seems to touch directly upon this question is the article by Sven-Olof Loden. I note that Professor Loden thanks me for checking the description. I've been unable to trace any papers. As I read Professor Loden's description of the UK system, including the operation of the FID system, it does not anticipate the AG's opinion in the FIG law. I was surprised if it did so, assuming that I must have read and approved that part of the paper. And the paper also addresses the steps that Robert Radler had taken to challenge the operation of the German imputation systems, which is what I was referring to. There was a challenge, although I think nothing came of it in the end for whatever reason. So then he goes on to 208. With hindsight, it can be seen that the description of double taxation offered by Peter Wattell in his 2003 review is only true in the case of juridical double taxation. The application of the developing single market principles in the context of the operation of an imputation system from the perspective of an origin state in the case of foreign dividends only began to be clarified with the decision of the ECJ in Lenz and Mannanen. These decisions, in my view, confirmed the approach that any difference in treatment resulting in less favourable treatment of a cross-border situation relative to a comparable domestic situation would be regarded as prima facie breach of the treaty, and essentially reformulated the cohesion justification in terms of whether the difference in treatment was compatible with the aim or objective of the member state system. The emphasis on the aim and objective of the member state system was also a feature of the reasoning in Marks and Spencer's. Lenz and Mannanen, coupled with Marks and Spencer, opened the door to the AG's conclusion, in his opinion, in ACT GLO, repeated in the FII GLO, etc. And then he goes on to consider what the Advocate General said. And his conclusion, I've said it in part two, the conclusions that I draw from this incremental case law, each case built on the last case. legal thinking developed about its scope and its application to new situations in the same way. At a general high level, it may be possible over time to discern trends in the case law. For example, the gradual move away from the language of discrimination towards the language of restriction and the identification of a difference in treatment. Similarly, the limitation over time of the cohesion justification, which is at first thought to allow a member state to defend its domestic provisions that were devised with a coherent policy objective in mind, and the clear denial of a justification based on fiscal considerations. The general high-level appreciation of these developments does not necessarily provide a clear signpost as to how the court will take forward its principles in more complex areas, or how it will choose to strike a balance between member states' competence in the direct tax field and the single market principles, given the inevitable complications of the coexistence of separate tax systems within the single market. And can I then just take you to what Mr. Gammy said in cross-examination about what he was saying in his report, what his evidence was. That's in the following bundle. If you, it's tab 14.
Of which bundle?
Oh, I'm sorry, it's a second additional document bundle, tab 14. And can I just show you the various ways that Mr. Gammy put what he was saying? So if we begin at page 489, internal page 21. And if you can read from line 16 on page 21 down to line 21 on page 22.
So what's the time to which this question is directed? You say what was the focus on what people were thinking about at the time? What time are we talking about?
Yes, yeah, that's right. I think in page 20 he says he puts himself back in the situation that one would have been in the mid-1990s. Yeah, in 1995 particularly. I think that's.
So you were putting to him that he was thinking about what he would have advised in 1995?
Well, I was asking him what he would have advised, because he hadn't, as far as I can see, given any evidence about that.
How far do you want us to read?
Just to line 21.
Thank you. So he does give evidence that if he had been asked, he would have said it's not a feasible claim.
Not a feasible claim, whatever. Yes. Well, that's what he says there. Yes. And then.
And do you accept that's the right question to ask, or is it not the right question to ask?
Well, we say it's not a question to be asked. It's not a question that would be determined by Mr. Gammy's answer. But what I'm trying to just give you is what Mr. Gammy said, because of course the judge relied on Mr. Gammy's evidence to make his findings as to what the position was then. I say that's not the correct approach, but I'm trying to engage with what the judge did at this stage. And so then if we go looking at, I'm questioning about breach and how that works, on page 490, internal page 27, and if you read pages 27 and 28, so the top of page 28, he then expresses it in terms of, therefore be likely to result in the court saying there isn't a breach. And I asked him about that, because that seems to be a slightly different position. You say likely, and I'm trying to ask him here whether he's expressing his own view, or he is saying that there is no other view. You can see I asked him, so if you go on to page 29, if you're advising at 29 line 10, and in light of that, if you're advising a client in litigation, why would you take such an extremely clear position where I understand you're taking that the positions are not comparable? There's no case law on it at all. And he says, I'm sure you're aware people come to you for your advice and you have to give your opinion as to what you think is the best situation. They can then go away and decide what they want to do with it. So it rather seems as though there he's saying, well, this is my view, my opinion. And we go on. And I ask him at line 6 on page 30, whichever way you put it, are you saying that's the only view, or are you saying that on balance you would believe that that was the correct view at the time? He says, well, again, expressing a personal view, that would have been my view at the time. I think he, if I would have been asked, but of course I'm trying to do my report is not just reflect my personal view, but reflect what my understanding was from all my contacts in other contexts as to what the general view would have been. And then we go on to discuss
This evidence is very clear, isn't it? I mean, he's saying that nobody from his contacts, and that includes himself, would have thought that the situations were comparable at the time, and therefore you wouldn't get past stage 1. That's really what he's saying.
I don't think he goes on to address whether you got past stage 1, my lady. What he's saying is, this is his evidence as to what.
Well, I've just read the whole passage, and I think that's what he was saying quite clearly. He's saying nobody at that stage would have thought this was a comparable situation. In the event that they might have thought it was a comparable situation, which I don't accept, then they might have gone on and said, well, it's probably justified anyway. But the sticking point seems to be thinking that the ECJ is even engaged here because of the view that direct taxation and indirect taxation were matters that were within the autonomy of the member states.
Well, with respect, I don't think it can be the last of these, because it was quite clear, certainly by 1996 and well before then, that direct tax is subject to European law. It's not within the autonomy.
Well, he may be wrong.
No, he's not. I mean, with respect, my lady, he's not making that point. He accepts that. I mean, I can find somewhere else. He accepts in his report, I think, the proposition that's set out in EC in France and Schumacher and whatever. I think he refers to Schumacher. It's clearly set out in Schumacher that direct tax, although it's a competence of member states, is subject to EU law, and it's subject to the treaty provisions. There's no doubt about that. That's not the point he's making, I think. The point he's making is that that in his view, they wouldn't be, non-resident and resident subsidiaries paying dividends would not be in a comparable position.
Yeah.
That's not to say EU law doesn't apply.
No, but he's talking about the competence given to each member state to set a system. So I'm looking at the passage at the bottom of internal page 27, beginning of in turn on page 28. You put to him, are you saying it's definitely not comparable without a shadow of a doubt? Is that what you're saying? And he says, well, I think it would certainly be a very strong indicator. You've got to ask yourself at that stage, is there discrimination? You haven't got into the restriction, language or difference in treatment. So you presumably conclude that actually as someone who subjects themselves to two member state systems, in a scenario where the treaty effectively gives competence to each, but it wouldn't therefore be likely to result in the court saying there isn't a breach. Now, you can make the point that he's qualified his answer by not being absolute about it, but it seems to me the general thrust of his opinion is very clear, which is you ask a lawyer at that time, is this a comparable situation? Answer no.
Yes, I'm not disagreeing that that's the view that a lawyer might give. And in fact, he's saying on page 2030 that was his view.
Well, no, I mean, if you read from line 10 on page 29 through to line 15 on page 30, it's quite clear that you understood that his evidence was that he would take a clear view that the things were not comparable. You see that at the start. You challenged him and said, but there's no case law on that. And then your next question at page 22, line 22 on page 29 is, so you're saying that you would advise that because that's what on balance you thought was the law, but you're not saying that that is the only view that could be taken on comparability. And then there's a bit more cross-speaking.
Yeah.
And so again, your question at line 6 on page 30, are you saying that that's the only view, or are you saying that on balance you would have believed that was the correct view? And he says, and this is at line 10 on page 30, that he was expressing a personal view. That's the view he would have given if he'd have been asked. But he also goes on to say, I'm not just reflecting my personal view, but reflecting my understanding, what my understanding was from all my contacts, both in practice and other contacts, as to what the general view would have been. So taking it in the round, he's saying both his personal view and what he understood to be the general view at the time was, anybody asked about it would have just said, not comparable.
Well, they would have said, that's my view, it's not comparable.
Yeah.
Yeah.
But,
They wouldn't have said, I don't think this is evidence, they wouldn't have said, there's no argument that it is comparable. Because clearly, as things stood, there was nothing to say that they weren't comparable, putting it that way. There was no principle. This was something that they had gleaned from, I suppose, international tax practice or whatever it was.
I'm not sure that's the right answer or the right question with respect. I mean, what Mr. Gammy is saying here is very clear. Ask anybody, can I get an argument off the ground? Answer, no, you can't. They're not comparable situations.
Well, I would strongly suggest he's not going that far. He's not saying there were no counter arguments to this, because clearly that would be...
He wasn't asked if there were counter arguments.
Well, I think he was.
Well, he might have been, but I'm not sure you gave him a chance to give an answer, to be
Yeah.
Well, he did. Well, he gave an answer.
Did he?
I asked him whether that's the only view, and he did give an answer.
Where did you ask him that?
At line 30, line 6. Are you saying that's the only view, or are you saying that in balance you would have believed that was the correct view at the time?
But then he says, well...
I'm expressing a personal view.
And trying to reflect my understanding was from all my contacts, both in practice and other contexts, as to what the general view would have been.
Yes.
In other words,
so
he doesn't say, I know of anybody who'd have expressed a different view.
I think we're talking about two different things here, my lady. I mean, the question is what... An advisor will express a view. I mean, if you advise someone on a legal point, you may give a very firm opinion that the law is X, but you might be saying, well, it's arguable the law is Y, but my firm opinion, maybe 60%, 70%, is that the law is X. And the fact that he thinks that all these people would have said the same thing doesn't make the point unarguable or absurd. It just means that all these people take the view that the better view overall is that it's not comparable. And that's likely to be what the European Court will say. I mean, that's what he's saying here. He never says this is completely unarguable to suggest that anything else, because he really couldn't, because it's clear that people were making arguments about it.
Well, not at that time, they weren't.
Not at that time, no. But they subsequently were. And
They
Mr.
did it
Gammie's
later,
view,
and the light dawns that it might be a runner.
well,
But the question really is whether or not, under the genuine consensus, if somebody hypothetically went along and said to a lawyer, have I made a mistake here? Have I paid tax in circumstances where I shouldn't have paid tax? The answer would be no, because we don't think the situation is comparable.
yes, well, they might go on to say, well, why do you say that, and how firm, how is that an absolute position? Because I don't think it's realistic to say that someone's going to go along to a lawyer and just ask that question and then get a one-line answer back. That's not realistic, and that's not.
All right,
how this test
I might go on and say, and here's all the 99 reasons why I say that the situation is not comparable.
Well, they can do that, yes. And therefore, and the reasons have got to be, good legal reasons, obviously. If that's the case, then that may be the position, maybe. If there were good legal reasons, I mean, supposing there had been a case that strongly suggested that was a position, a matter of EU principle. I mean, if there had been a case which said, for instance, generally we apply international tax principles in the EU, then you can see why you might draw from that the fact that you apply international tax principles. There wasn't any case that suggested that. That was something that all these people, if Mr. Gammie is right as to what they thought, that's what all these people, they were just taking that from international tax principles and saying, well, because it's something we've been doing for years, it must be okay. Essentially, it seems to be the argument. Because I did put to him that we'll see that if he was right, that would mean that member states could discriminate as much as they liked between non-resident and resident subsidiaries, and restrict freedom of establishment as much as they liked, because you would be preventing, discouraging people from establishing in another state, which is clearly within freedom of establishment. Be okay. Now he said that wasn't the case, but he was never able to explain why. He never explained why they were not able to discriminate as much as they liked. It seemed as though his view was that they weren't comparable in this situation. But if you discriminated more, perhaps they would be comparable. I think must be what he was thinking.
What was HMRC's defence in the litigation? Not agreed that the situations weren't comparable.
No, I don't think that was right, because you have to remember, by the time we got to the reference, we had Mannanen and Lenz. So that argument was completely out of the window. I don't think that was what was from my recollection. In fact, we were relying on Mannanen as part of the defence, as I seem to recall. That's my recollection of it. So, if we just go on to what he's saying about why people weren't considering the position. And it's on page 33. Just at line 20, I say the reason it hadn't crossed their mind, this is when he's making the point that it hadn't crossed people's mind. Could just be if they hadn't thought about it at all. The impression he seemed to be giving is hadn't crossed their mind because it was so obviously wrong that it wouldn't cross their minds I'm simply saying, why do you assume that? No, I explain in my, so the starting point had not crossed their minds, okay? So I'm prepared to accept that. Insofar as I have any explanation as to why it hadn't crossed their mind, I gave that explanation in my report, because basically speaking, there were these stepping stones that the court had not gone through. And so this is referring to the Mans, the Lenz, and then Marks and Spencer's, etc. So what he seems to be, well, what he seems to be saying here is it hadn't crossed people's mind because these cases hadn't been decided, but that would then lead to the decision. And that does make some sense, because until Lentz and Mannon, there would be nothing to, jog people into thinking about perhaps this point. Although in fact we know that some people in the UK did think about it before then. But I think that's essentially what he's saying about people, why people didn't cross their mind, why they didn't think about it. Simply because there hadn't been these cases which talked about dividend taxation. Once there were, of course, everyone would be thinking about it. And then he goes on to talk about, the issue that no one is discussing. And then we come to the mountain and the mist. And that's at page 35, line 17. He says, I know you can't see a mountain for the mist to cover it. I don't know that there is a mountain to climb. But once the mist's clear, you can see there's a mountain to climb, and you can decide whether in fact it's capable of being climbed. It seems to me it's for this court to decide, as you make quite clear in my report, what is the nature of the test the Supreme Court set. And I was not trying to answer that particular question, insofar as nobody, this was not an issue that had come to my attention, if you like, put in those terms in the mid-1990s, of course. I can't say whether out there wasn't somebody who might have been thinking about it, or whatever, but it was not something that came to my attention, as far as I can offer a reason as to why in the 1990s that would have been the situation, and nobody had identified it and talked about it. My reasons are in my report. And he says, well, I don't think they're speculation. I said they're speculation. They reflect my understanding of the general view of these things. I'm trying to put myself back in the mid-1990s, discussion I had around Hearst, Schumacher, Wheelock, etc. What my understanding of the mindset then. I don't know, we were criticised for using mindset, but that was Mr. Gammy's word, the understanding of the mindset. And he goes on to talk about that. And if we so if we move on to page 53, he's talking about the long-standing understanding. The long-standing and accepted understanding, so far as I can speak to it, that's on line 19. I'm trying to understand where you get that from and how the evidence, there doesn't seem to be any evidence of it. Quite a surprising and astonishing proposition, really, given the case law of the European Court. We will find it discussed in Farmer and Lyle. And he says, with respect, Farmer and Lyle is a publication in the 1990s. What I'm talking about is a long-standing accepted understanding of the position, which of course informs where you start from. So as I put it before the very short break, the mountain was covered by mist, or could not be seen, right? And now you're in a situation where the mists are beginning to clear, if you like. If I can put it in those terms, and you can see that there is a mountain there, but can that mountain actually be climbed? That's another matter. Right, but Farmer and Lyle's book was published in 1994. Are you saying this long-standing accepted understanding didn't exist in 1994? Well, if I'm talking about long-standing accepted understanding, I'm talking about, if you go back to the 1960, all the reports, all the discussion, all the debates, in the 1970s, 1980s, right up to the point where you have the French package, Appearance of Subsidiary Directive. That's a background, right? To what then, when the mist starts, I say, using that analogy, the mist starts to clear, and you can see there is a mountain, and the question is, well, is that a mountain that can be climbed or not? And when using their analogy, did the mist start to clear? Well, I say in my report there were a few cases, but in particular, I think Schumacher was a sort of invitation, if you like, to people to start to question, is this or is it not a breach of something we can challenge in the European Court? Okay, on the basis that member states have competence in direct tax matters, they have to exercise that in a manner that's consistent with the treaty. So that's the point he was obviously aware of. So what he's saying here is that in the mid-1990s, you were able to, the mountain, I think he means, is climbing the mountain means getting to the FII decision. And what he's saying is that by the mid-1990s, you could see the mountain, but you didn't know whether you'd be able to climb it or not. That's his analogy. So he continues with that on in page 56. You're looking back at where you are now. You've been in a situation where you didn't even know a mountain was there. Now you're suddenly getting to realise there is a mountain. The question is going to be over the coming months, years, is this a mountain that can be climbed? Assuming you have a mindset like it's climbing. And I think he goes back to this idea. Yes, on page 81, on page 504. And where I asked, right, so we can't take it from your report of what you said in evidence, that your evidence is that at any particular point you would have been advising people that there was no point even considering a claim or investigating. You're not saying that. Sorry about all the double negatives. But you're not saying that. I think from your last answer, I think I understand you're not deliberately not giving evidence on that question. No, as I explained in my report, that seems to me to be an issue for this court to decide at what point, as I think the expression has been used there, was a worthwhile claim. What I've tried to describe is my understanding of the general understanding of law at any particular point in time. And as I say, once you know a mountain is there, the question is, can it be climbed? People may take different views about how, and you're not able to give any idea when you think the mountain came into view. Well, I think, as I already said, the mist certainly began to clear around the sort of mid-1990s, of course, because you've got a certain number of cases, and what you're trying to assess is, when you say, where do these cases lead? Ultimately, you've got, as I say, between, I think it's Judge Watterley in his 2001 lecture says, you know, between 1996 and 2000 there have been 50 cases, majority of which fell within 97, 98, 99. Of course, as that develops, you're thinking about how far up the mountain people can get is developing. But of course, there were people who were the intrepid climbers who went first, I said. Of course there are. When I say there always have to be, but certainly in the mountain context, there always has to be some intrepid climber who may get halfway up and then fall and kill himself. Or he might get to the top and might even fall, as regrettably have been a number of occasions on the way down, and then as a diversion onto someone falling off a mountain, I think. And then he goes on to say, anyway, that's by the by, but of course there are always intrepid people who will aim to get to the top. What I deliberately tried to avoid doing in the report, because it doesn't seem to be relevant in answering the question, this Mr. Justice Falk had said, was to express a view as to whether or not I thought that was worthwhile, that you set out to climb a mountain not knowing whether you can get to the top. Essentially what he's, in my submission, what he's saying in all this is, in the mid-1990s, you could see that there was a possible claim, but you didn't know whether you were going to get to the top of this mountain and succeed. And you only knew that you were going to succeed once you had the decisions in Lenz, Mannanen and Marks and Spencer's. At that stage you knew that you would be able to get to the top of the mountain. And that in my submission is the approach he's taking.
Would you say that it's the answer at 8211, the mists certainly begin to clear around sort of mid-1990s? And he's already identified that the mountain means the question that Lady Justice Falk directed the evidence towards, which is the FII question.
Yes.
So is your submission that once the mists begin to clear, you know there's a real question, and that's enough?
Oh yes, absolutely. That would be my submission. That, if using that analogy, I'm not sure it's very good. It's a good one, but yeah,
you said it was a very good analogy at the top of page 80.
Yes, I think
you were just being flattering.
I think that may be the case.
But
I think I was referring to the extension of the analogy to intrepid claimants falling off the mountain, etc.
Yeah.
May have been a joke, yeah, I would say that shows you what he's getting at in his report and what he's getting at his evidence, that he was looking at whether you could say that you could get to the top of the mountain, whether you could actually.
Well, no, but when he's talking about you didn't even know there was a mountain there to be climbed.
Well,
that was, he said, the general understanding was, long settled, accepted understanding was, that the problems caused by cross-border dividends simply weren't a problem that could be solved by using the treaties. They needed legislation, they needed member states to get together and agree something. And that's the thrust of his earlier part of evidence.
That's right. But then when I said, well, you can't find this in Farmer and Lyle, he said, well, by that stage, what I'm talking about is a long-standing, going back to the 60s, 70s and 80s. And by the mid-90s, I think the point he's making here is you were able to begin to see the mountain, but you didn't.
You could see there was a question, even if you didn't know whether it could be answered favourably.
Yes, exactly. And his view, I think it's fair to say, was, certainly at that point, it wouldn't be answered favourably. But you could see there was a question.
And my question to you was, do you say that that's enough to see that there's a real question?
Of course, yes, absolutely. Because we are, go back to this, we're just looking at whether you got sufficient notification that there was a mistake so that you could then go and investigate and do whatever you need to do. I mean, the position in relation to limitation periods is generally the case that you don't have to wait until you will get positive advice.
No, but Mr. Hewitt, there's a world of difference between knowing that there's an argument that you've made a mistake and knowing that there's a mistake. I mean, we're talking about a viable claim, not just a claim. So viable has got to mean something. It's got to be, and if you don't know whether it's even going to get off the ground,
well,
you say, the claimants have got to prove that anybody would have told them it was hopeless. That seems to me to be setting far too high a threshold.
Well, that is my submission, and that is consistent with the Supreme Court judgment, and it's consistent with limitation in other fields, in other areas. And it's consistent with general position in limitation, where you haven't, where your cause of action is not based on mistake. Even if you've made a mistake, you don't get any extension of the limitation period. And that would happen even if you had been advised that you didn't have a claim, and that the reason you didn't claim in time was because you had been advised you didn't have a claim. You would still not have an extension of the limitation period. So limitation doesn't work by reference to whether you've had positive advice or even the level of advice that you get.
I'm sorry, Mr. Hewitt, you're mixing apples and pears, because in that context you're dealing with knowledge of facts. Here we're dealing with knowledge of a mistake of law, and therefore you've got to bring in the question of advice, because you don't know whether there's a mistake of law or not until you've got the advice. So you aren't comparing directly two situations.
Well, the example I had in mind wasn't whether there was a mistake of law. So I was thinking of an example of, for instance...
Yeah, exactly. That's what I'm putting to you. That you're comparing apples with pears, because the alternative situation, which is the general limitation position, is that somebody may have the wherewithal to be aware of facts, and it doesn't then matter whether their lawyer gives them duff advice about whether they've got a claim or not, or even good advice about whether they've got a claim or not, because if they are on notice of the facts, or could with reasonable diligence have found out those facts that would give rise to the cause of action, the legal advice is irrelevant. But in this situation, the legal advice is an integral part of knowing that you've made a mistake.
The example, the example I was thinking of was, for instance, a breach of... It was not a case about claims in mistake, but it was a case where you did make a mistake. So, for instance, a breach of contract where you didn't know there was a breach of contract due to mistake, and maybe you've been advised, as I said, by your lawyer at the time that there wasn't a breach of contract. subsequently there was some case or some decision that showed that in fact that was wrong advice, you were in breach of contract, you're not going to get any extension of limitation period simply because the reason that you didn't bring your claim was because you had wrong advice, although maybe not negligent, but wrong advice at the original time. The 6-year limitation period would simply apply in those cases. It's only in these very particular cases where the cause of action is based on mistake. That's one of the ingredients, because that's what the Supreme Court said in Supreme Court 1. It's only in those cases that the extended limitation period can apply. So, in general, the position would be that you would simply have to, the limitation period would start, and whatever, the fact that you didn't know you had a claim because you were mistaken, and the fact that you got bad advice would not, or good advice, which sounds wrong, would not make any difference to the limitation period. So what the Supreme Court here are trying to do is say, as long as you're in a position where you would have been alerted to the fact that there was a possibility of a mistake, then you can't claim the limitation period extension because you're not in any different position from anyone else once that's happened. And the fact that you're being told that you're going to lose at that point cannot help you to extend the limitation period. Can I take you to the judge's judgment, because I don't have very long, and we ought to. But there is a passage in that which, to some extent, deals with this. It's in the core bundle. Sorry? Ah, corrected. The slip route. Is it? Where is that? Sorry? I've got tab 13. 14. 40. Oh, I don't know.
14 is the applications for permission to appeal. 13 is the substantive.
Yes. I don't know if there's any difference. If there is any difference, you can tell me.
There was a small amendment.
All right. I'm looking at page 187 of the bundle, paragraph 21. And it's where the judge is setting out the conclusions. And it's particularly subparagraphs 4 and 5. Particularly paragraph 5. The questions posed in paragraph 4 are not directed at when the claimants could have expected the pleading claims would succeed, nor are they directed at a complex evaluation of chances of success. Although, of course, if at a time all the claimants would, with reasonable diligence, have discovered that a claim would be struck out as disclosing no cause of action, they would not have discovered a worthwhile claim. And that taken from Gamalto, you can see paragraph 47. So it's not a matter, first of all, it's not that you'd be advised that you will succeed, but it's also not a matter of evaluating chances of success. It's much more stark than that in my submission. And I think that the judge is right about that. And all the court has to determine is have the claimant shown that at the relevant time they could not have discovered the mistake. In other words, that all they could have discovered at the time was that any possible argument, any argument in relation to the mistake, in this context, breach of the treaty, was hopeless.
Do they not have to show that
Would be struck out as one.
you completely missed out of that formulation what they would have been advised, or what might have been advised, or could have been advised, had they consulted people in the marketplace in reality at the time. I mean, you're saying that's not the relevant question.
Well, if by that you mean that somehow the advisors would have some special characteristics, which would mean that they wouldn't, they would advise that a claim was hopeless, when a judge looking at the objective circumstances would conclude that it wasn't hopeless. If you're saying that, then I would say that is irrelevant, because then you're imposing on the subjective test that some kind of
I didn't put it.
characteristics of the advisors.
No, I didn't put it very well. My understanding at the moment of the exercise that the Supreme Court envisaged is to, I haven't got the exact words in front of me and I probably should get them, but they talk about a well-advised a multinational entity, which focuses attention on what people would have been told if they had done what people normally do with tax, which is to consult lawyers in the market who are available to you at the time. And do you say that is the exercise that the Supreme Court envisaged?
I don't think I would submit they didn't envisage asking factual questions about what kind of mindset lawyers had at the time, and saying because they had a particular mindset about something, then they would have given certain advice. I would submit that's not the...
Because that was the agreed question that Mrs. Justice Falk ordered to be considered by the experts, which you adduced one.
Yes,
I mean, the question was...
It doesn't mean that I can't... I'm submitting that the decision in the end is for the court. I mean, if I'm wrong about that, obviously we do have to deal with the...
Well, by consent it was ordered by Mrs. Justice Falk, as she then was, that expert evidence should be served, quotes, on the subject of how legal thinking on whether the UK tax treatment of dividends received by UK resident companies and non-resident subsidiaries in the form of ACT on subsequent distributions and tax on dividend income was compatible with EU law, developed in the period to the 18th of December 2003. So that was the agreed order for expert evidence, which we saw referred to in the cross-examination materials that you're taking us to.
Yes, but that doesn't envisage...
You're saying now that actually, that understanding that was the agreed order for expert evidence, that actually is not the right question.
Well, what the Supreme Court say is that it may be relevant to the determination of the question that the judge has to answer. But what I'm saying is it's not determinative of the question, in the way that you maybe seem to be suggesting that if the evidence is that advisors had, or a certain cohort of advisors, because remember, Mr. Gavi makes it clear he can't speak for everyone in the, who's advising, but a certain cohort of advisors had a certain viewpoint at the time. That wouldn't necessarily conclude the question that the judge has to ask, which is, could you discover this mistake? Because
could who discover the mistake? Just
could a well-advised multinational in the position of the claimants?
Right.
Sorry, the claimants.
What does
who are well-advised
mean
multinational
in this context then?
Well, well-advised means getting the best possible advice that could be given in the light of the law as it stood. And so the court can quite easily decide that itself, because the court is in a position to determine
Well, we've been
whether
at
they
the
would
houses on that particular point several times already, I think, with the point my lord put to you yesterday, which is that if that were the case, the Supreme Court wouldn't have given us this task. They could have decided it then and there, looking at the
Well,
case law.
I don't, you've had my submissions on that. That may be a
But we
matter.
have the point.
Yes. I mean, it's quite obviously this is important that we are clear about what the test is and what's to be done. Because as I said, there may well be other claims where this will have to be worked out. So we need to know whether it's legitimate, whether it's legitimate to do what Mr. Gammy did and to sort of give evidence as to what they thought at the time and they thought other people thought. Because undoubtedly, if that is the right approach, then that's what's going to happen in subsequent cases, and no doubt we'll have a number of different witnesses giving different evidence about what people might have thought at the time.
There will be a whole industry for retired barristers.
Yes, yeah. Oh, it's great. But you're disqualified. Exactly. Whereas, in my submission, it's in a sense a straightforward question that a court can decide. You don't have to decide what the chances of success are. You don't have to decide how great it is. All the court has to decide is looking at the principles that have been established at the time, what people were saying about it in academic articles or whatever at the time. The court just has to decide, well, essentially, is this argument hopeless at the time, or is it not, depending on the circumstances. And the idea that it wouldn't be hopeless in a circumstance like this is not a particularly striking one in my submission. This is not a case that the court talks about where there was a decision, any decisions that were contrary, let alone a decision on the point. Nobody's pointed to any case law which was against the claims. All the case law, in fact, all the principles that were established in the case law were supportive of the claims at the time. So we submit it's a much simpler question than the judge made of it. What the judge did, just look, is he constructed the appropriate advisor and he sets out what the appropriate advisor would know or believe, paragraphs 58 to 65. And in my submission, almost all of that, of what's set out there is legally irrelevant to the question that you would be asking yourself. And we're now concentrating on this idea of the appropriate advisor. But the appropriate advisor would be asking himself, not look at all this background that's gone on in the last 30 years. He'd be asking himself, what is the position in 1995 on the basis of the case law? And the only piece of relevant legal knowledge that is attributed is paragraph 63, which is the point that tax is not a no-go zone.
Are you saying that the whole concept of the appropriate advisor as a concept is just completely wrong?
Well, it's completely wrong if it's used in this way.
No. Are you saying that the judge should not have accepted the concept of an appropriate advisor at all?
Well, he could have well, what he could have done is ask himself, without constructing this appropriate advisor, what he was essentially asking was, what advice would have been given? What advice do I think would have been given at the time, based on the law as it stood at the time? That's what he should be asking. Now he can ask that in the sense of saying what would a competent advisor have asked, but he doesn't have to set up a factual appropriate advisor who's given characteristics of people at the time, and who would, rather than looking at the legal principles and deciding whether there was a possible case or not, in fact, what I think he concluded that he would do was simply say, well, there is a consensus that there is no claim, and therefore that's the advice that he would give. And It's not even a realistic
But I'm
construction.
I'm struggling with this. I thought that the logical consequence of your submission to us that we could have done it, that we could do it, or indeed as we
judge
put
could
to you
do
that
it.
the Supreme Court could have done it, means that the whole appropriate advisor concept, if that means anything, is just irrelevant. But that's not actually your appeal. I mean, your ground. I don't actually think that submission is within your grounds of appeal.
I think ground 2 is saying
Your ground 2 doesn't say. You say that the appropriate advisor was constructed in a flawed manner for a number of reasons, but you don't say you shouldn't have been even thinking about such a thing.
well, no, because one way of I think we say one way of approaching this, one tool is to ask the question, what would have been advised at the time? But that's simply a tool for the judge in asking his question, which is assessing what the legal position was at the time. But that's what you'd expect a legal advisor to do. You see, there shouldn't be any difference between what the judge will conclude and what a legal advisor would have concluded at the time, as long as the judge is not using hindsight and is just looking at the provision, looking at what was there as a matter of the legal provisions. The judge is in exactly the same position as the legal advisor at the time to decide that. So what I would have anticipated if you were doing this would be that you would be the notional legal advisor, if you want to use that tool, would be simply looking at the law and concluding on the basis of that what advice would have been given. And the judge could use that, as I say, as a tool in deciding how to answer the question that he has to answer. But the answer shouldn't be different. And it shouldn't be the case that, since it's a matter of law, that somebody advising, that you should set up someone called the appropriate advisor who would take a non-legal approach, essentially, to all of this, but who would follow what I would submit would be a non-legal approach. It's not an approach I've ever known adopted in my advisory work, which is to say, well, everybody thinks this is the position, therefore that is it. There's your advice. I'm not going to consider any more. Everyone thinks it. And the judge then goes on to say, to accept that you might go to an EU law specialist who wouldn't be within the magic circle. That's in paragraph 79. But he said even, sorry, not paragraph 79, but even, even the EU law advisor would defer, he says, to the consensus amongst the UK tax advisors on the question of comparability. And we say that's simply wrong on any level, because the question of comparability, what the judge doesn't
Well, shall we pick
appreciate
that up at 2:02?
Yes, I don't want to take too much time because I know I'm supposed to finish by lunchtime.
How much longer do you think you're going to be?
All I'm wanting to deal with is the decision that we're looking at. So
All right.
I imagine in 10 or 15 minutes we can finish up if that's.
All right, 2:05.